Hello, everyone, and welcome to Uncivil Law. For today's case, we are dealing with when ballots can be mailed, can they be received, what are proper dates for ballots as part of the presidential election. And this comes from the state of North Carolina, which has tried to regulate around this area. So this case is the case of Patsy Wise versus Damon Criscotta in his capacity as chair of the Board of Elections. In this case, North Carolina tried to modify the rules dealing with when ballots can be mailed, when they can be received. Is it proper? Is it not? Let's get started with this. The North Carolina Alliance for Retired Americans and several individual voters filed suit against the State Board of Elections in North Carolina on August the 10th, challenging, among other provisions, the state's requirement that mail-in ballots be received within 3 election days. So the law said you have to receive the ballots within 3 days of the election. On September the 15th, the State Board of Elections voted unanimously and in bipartisan fashion, and the court here puts an exclamation mark because I guess they're surprised that something was bipartisan when it comes to elections, but apparently yes. So the board voted unanimously to extend the receipt deadline for an additional 9 days after Election Day. So there was a requirement be received within 3 days, and said, no, we want it within 9 days, not an additional 9 days. I'm sorry, I misspoke there. A total of 9 days, so extended by 6 days. Under the status quo, all absentee ballots cast by Election Day and received by the 12th will be counted. So they have to be mailed by Election Day and postmarked presumably, but they don't have to be received within 3 days. They have to be received within 9 days, says the State Board of Elections. Is that a thing the Board of Elections can do? Let's read on. As a result of prior litigation related to this case, the ballot receipt extension has gone into effect. And thus the question before us is only whether to grant an injunction, which the district court denied, of the extension. So the prior litigation in the state has been unfruitful in terms of undoing this. The ballot extension has gone into effect. The district court denied the injunction to prohibit it. And so the question before us is, should we enjoin this? So the state court, having decided that the extension should go into place after the Board of Elections decided the extension should go into place, the question is, what is the role for the federal court in this circumstance, if any? What should the federal courts do and not do in response to state election proceedings, particularly ones that are so close to the election? Let's read the standard that applies. From the outset, a case called Purcell strongly counsels against issuing an injunction. Yeah, there's a U.S. Supreme Court case called Purcell, and it basically says the federal courts should not interfere with elections, particularly when they are very, very close to the election date or ongoing. So Purcell basically says, please don't do this unless you really, really have to. The status quo, that is, what is the state of things that exist, is plainly that the ballot receipt extension is in place. So the current existence is the extension exists. The extension took place after the district court's TRO expired and the state appellate court dissolved it in action. But even before those injunctions lifted, the ballot receipt extension had been the status quo since the trial court approved a settlement. So there was a settlement in trial and the extension had went into place. The Supreme Court recent decision in Ardino instructs it is not federal court decisions, but state court decisions that establish what the status quo is. On Ardino, there was a law that continued to be put in place for the November election, and the district court enjoined that thing. And then this judge, writing for himself, says, my view was that the injunction at the time of the primaries establishing the rules was the status quo. So we have to figure out what is the status quo in this situation. What is the status quo? And this judge says, well, my view was the status quo is basically whatever the last thing to have happened was. So it was what the federal district court, that was the status quo because they have already ruled. But then the Supreme Court said, no, not so much. That's not the status quo. Then the judge, right, apparently with a little sarcasm or a little bit of spite, says, apparently then it's the state action, not intervening federal courts, that establishes the status quo. So yeah, that is the interesting issue. So when you're thinking about injunctions, which are in order to do something or not to do something, they're only an injunction to do something or not do something with respect to what is already happening in reality, right? And so then whatever happens is now the new status quo. That's one of the operative things that court cases do is change what the status quo is. You can see that in criminal cases, for example, the status quo at the start is the guy is innocent. If he's convicted, the new status quo is the guy who's guilty. That is what is already operating. So the Federal Court of Appeals was noting that it thought that what the district court did was the status quo. And the U.S. Supreme Court said, no, that's not the status quo. The status quo is whatever the state did. So the district court is not changing the status quo no matter what it does. So you got that one wrong. So look back at the state action and figure out what the status quo is. Here, the state's action from its state courts and state procedures was to implement the modifications. The status quo, therefore, became established on October the 2nd, when the state court approved the settlement related to its proceedings. And the district court agreed with this. Not that it matters either way, because no matter what the district court says, it would not change the status quo. The status quo is what happened on the 2nd, end of analysis that. So Purcell and Ardino therefore require us that we refuse to enter the injunction here, because the states have spoken. We are not supposed to do this. That is the status quo, and no, not so much. And then the dissent is really, really salty about this for some reason. The dissent says you got it wrong. The Parnell speaks to courts interfering with elections, and so you should look to what the state courts did and their interference. So you got it wrong by not considering the state court's interference with the proceedings. Parnell speaks to that. And then the Court of Appeals is like, no, not so much. That's not what Parnell is about. So contrary to our dissenting colleagues, Purcell is about federal court intervention. So Purcell is only a case dealing with whether federal courts should intervene. States are in control of their election procedures for better or worse. And Purcell just speaks to whether federal courts should get involved. Whether or not state courts should get involved, Purcell has nothing to speak with. And there might be concerns there for state courts to get involved or not, but that is really not our concern as the federal government, not our concern as federal courts. If state courts want to modify their election procedures, that might be a problem for some other reason, but Purcell doesn't speak to that. It just speaks to the federal government staying out, so no. Our dissenting colleagues attempt to stretch the Purcell case beyond its clear limits to cover not only federal court action, but also action by state courts and state executive agencies, acting pursuant to a legislative delegation of authority, which proves too much. They cite no authority for this expansion, and there is none. No. Instead, our dissenting colleagues assert there's no principled reason why the rule should not apply to interferences by state court and state agencies. I can think of a couple, actually, like, state-level sovereignty, federalism would be some concerns. But this concern from the dissent would actually flip Purcell on its head. Our colleagues in the dissent justify the federal court intervention, the one thing Purcell clearly prevents based on their own notions of what the Supreme Court should have said in Purcell. The Supreme Court was trying to speak to what state courts did too, so you should intervene. And the majority is like, but the court said specifically federal courts shouldn't intervene. So you're saying that we should do something that would directly defy Supreme Court precedent based on what you think they should have said? No. We cannot agree with this expansion of federal court power at the expense of state rights to regulate their own elections, which is within their provenance. To do so would amount to improper judicial activism. So the dissent over here is all like, the Supreme Court wasn't just speaking to federal courts. It was also speaking to state courts. And so you should look at the state court interference, and you should interfere with the state court's interference by you interfering, which is the one thing the Supreme Court said you shouldn't do. And the majority is like, no. The case says we shouldn't interfere, and you want us to interfere because they said what they really meant to say is no court should intervene, including state courts. No. Turning to whether the plaintiffs are likely to succeed on the merits, the district court concluded that the election board violated equal protection when it extended the deadline for receipt of the ballots postmarked from election day by 3 days after election to 9 days. And the court relied heavily on Bush versus Gore and said, this is an equal protection violation because you have extended some people's rights at the expense of others. So Bush versus Gore says you can't do that. Are they right? This case totally lacks the concern with arbitrary or disparate standards that motivated Bush versus Gore. The standard could not be clearer or more uniform. So this is not a lack of uniformity problem. Everyone's being treated the same. What are you talking about? Everyone must cast their ballot on or before Election Day, and ballots will be counted for everyone as long as they're received within 9 days. So there is equal protection. Nor will the ballot receipt extension lead to unequal evaluation of ballots, because everyone's ballot is worth the same under the extension. So under the old rule, it had to be received within 3 days. So if you complied with the old rule, your ballot was received within 3 days and it would have been counted. Under the new rule, you get more time. But if you voted earlier, you haven't been harmed because your vote is still being counted the same. This doesn't make sense. Moreover, in a sharp departure from an ordinary voting rights lawsuit, no one was hurt by this extension. The extension does not in any way infringe upon any person's right to vote. All eligible voters who want to vote can do so on or before Election Day, just like they could before. What are you talking about? Instead, several of the plaintiffs have already voted. How have you been hurt by this? You voted. The extension simply makes it easier for people to vote absentee in the middle of a global pandemic. How this implicates equal protection, a key provision that protects individual rights to equal protection, is beyond our understanding. This hurts your equal protection claim because your votes have already been cast and counted? How's that a problem? We don't get it. I don't really get it either, to be honest. But wait, there's more. Plaintiff's equal protection argument is plainly in conflict with the Supreme Court's recent action in Ardino, when the court permitted votes that lacked a witness signature to be counted so long as they were cast before the Supreme Court's stay issued and were received within 2 days of the order. If a board absentee ballot receipt deadline violates equal protection by changing rules mid-election, so did the Supreme Court's order in Ardino, which, not so much. Furthermore, even if you had standing to pursue these claims, which you don't because you haven't been hurt, and being hurt is kind of a prerequisite to standing, yes, the Pullman doctrine says we shouldn't do this. There's an abstention doctrine. Pullman abstention doctrine applies when there's an unclear issue of state law presented for decision. If it's unclear, the federal court shouldn't speak to it because states have control over their own law, and the resolution for which may be moot or present in a different posture. The federal constitutional issue, such as the state law, is potentially dispositive. So if the state law is controlling and you don't know what it is, you probably should stay away from that case. Let the state courts figure it out. Here, the plaintiffs are asking federal courts to determine whether the board acted within the scope of its authority by the legislature. So was the board within the province of the legislature? And that, as you might anticipate, is a close issue, but it's a close issue of state law. Was the board within its authority? It's an issue of was it within the authority of the legislature? That's a state law question. That involves competing interpretations of the North Carolina statutes governing election procedures and implicating complex questions concerning separation of powers in the state. None of the parties have suggested or argued the state courts have already settled this issue conclusively. Indeed, the state court that approved the consent judgment and rejected plaintiff arguments as this issue, while the district court reached the opposite conclusion. So, what the state law is, we don't know, and we're not going to figure it out, and you guys have already settled amongst yourselves, so it's really no business of ours anyway. Few cases implicate the dual aims of the abstention doctrine, avoiding advisory constitutional decision-making, we don't do advisory opinions, and promoting the principles of comity and federalism more strongly than this one. This is a good reason for us to stay away. We do respect state courts. We do respect federalism. Our role as federal courts is, we have a limited role, and this is a good reason to stay away. So therefore, we should stay away from intervention into these local affairs. Sounds about right under the operative federal law, yes. Accordingly, this court must deny the requested injunction. To do otherwise would risk endangering a great many of our doctrines, to say nothing about the health of voters of North Carolina as they attempt to safely exercise their right to vote. Thus, that brings us to the end of the case dealing with the mailed-in ballots in the state of North Carolina. The North Carolina Election Commission decided to extend the deadline to receive the ballots by an additional 6 days, from 3 to 9. They still must be cast before Election Day, but they gave more time to receive them. And as far as the state was concerned, they settled that out and they reached an agreement that that was totally okay. And then someone came to federal court and said it's not okay. And the Court of Appeals for the federal government says, yeah, no, this is a situation where we should get involved. No one is being harmed from this. No one's being denied equal protection. Everyone had as much rights as they did before, perhaps a little bit more, but no one's being harmed. And also, there's good reasons for us not to get involved because we've been specifically commanded by the U.S. Supreme Court not to get involved in this situation. So we're just going to stay out of it. And yeah, this is perfectly fine. No problem here. And that brings us to the end of the discussion of this case.